Hello, everyone. This is Tom Fox back for another episode, and hopefully, you will see a familiar face if you're watching this on YouTube because I have back with me Jonathan Wilson. First of all, Jonathan, welcome back, and thank you so much for taking the time to visit with me today.
Thank you, Tom. I appreciate the opportunity to be here.
Our listeners will recall Jonathan as one of the true subject matter experts in the Corporate Transparency Act, was way ahead of the curve in getting up to speed on this act and getting his clients, ready to comply with the act. We recently had a district court decision out of the Northern District of Alabama entitled National Small Business Union versus Janet Yellen et al., which invalidated the CTA, at least in the Northern District of Alabama. So I wanted to visit with you today, Jonathan, about this case and maybe get some of your thoughts. So, with that, could you describe generally the background of the case?
Absolutely, absolutely. And I would point out that the court's order only applies to the parties to that case. It's not necessarily binding on everyone, even within the jurisdiction of the Northern District of Alabama. But the NSBU case involves an individual, Isaac Winkles, who sued the Treasury Department seeking to have the CTA declared unconstitutional. And he was joined in that effort by an organization, National Small Business United, that claims to have 65,000 small business members. And they had two primary constitutional arguments. And as everybody remembers from law school, Congress is only able to legislate inside of its enumerated powers. The Constitution gives Congress power to make laws in certain areas. Congress does not have plenary power to make up whatever laws it wants. One of the areas where the Constitution gives Congress power is involving interstate commerce. The Constitution describes commerce involving foreign nations and among the states. And so Congress traditionally has been able to adopt laws that restrict, guide, regulate commerce between the states. It's one of the reasons why we have labels on products, for example, because we have a federal product labeling act. This particular court found that Congress's power to regulate commerce between the states was not so broad as to enable it to adopt the Corporate Transparency Act, requiring owners of small businesses to file their BOI reports with FinCEN, as we expect. And I'm sure we'll dig into that. The second constitutional grounds has to do with Congress's power to legislate in areas involving national security and foreign affairs. We have become accustomed to thinking about the president as the commander in chief, commanding the military. But in fact, Congress has the power to declare war, and constitutionally, it's Congress that is supposed to manage the country's foreign affairs and national security. And this particular court, at the request of this particular plaintiff, held that Congress's power to manage foreign affairs and national security was also not sufficiently broad to empower Congress to adopt the CTA in the way that they adopted it. So those are the two chief arguments in the case.
So the court invalidated the statute. Could you go through perhaps some of the reasoning that you saw in that?
Sure. So as it relates to interstate commerce, the government, represented by Janet Yellen as the Secretary of the Treasury, said that the CTA was within the Commerce Clause because the Commerce Clause has been interpreted by the Supreme Court many times to empower Congress to adopt laws that have any effect on commerce between the states. The case that this court talks about the most was called Gonzalez versus Raich. And that was a case where federal anti-marijuana laws were applied against an individual in the state of California. And it was stipulated for that purposes of that case that the individual possessed a marijuana plant, that they had not purchased it from anyone, that they were not going to sell it to anyone, that they were going to use it solely for medical marijuana purposes, which were legal in the state of California. The individual was prosecuted under the federal anti-marijuana statute. The individual appealed that conviction, saying, Congress lacks authority to criminalize marijuana when I am possessing it solely as an individual inside of the state. I'm not selling it. I'm not affecting interstate commerce in any way. The Supreme Court, just a few years ago, disagreed. The Supreme Court said Congress has ample authority to criminalize marijuana, even in the case of an individual using it within a single state, because that individual's consumption of the marijuana takes away from their need to purchase it on an interstate basis. And therefore, the regulation as a whole has an impact on interstate commerce. That was the analysis in Gonzalez versus Raich. What this court said was possessing a marijuana plant is a quintessentially economic purpose, which affects interstate commerce, but the act of forming a corporation is not a quintessentially economic purpose, and therefore it is beyond the scope of Congress's interstate commerce authority. That was the court's ruling, as I understand it.
Jonathan, there was one other point that you've discussed, which was that the CTA was an unconstitutional infringement of individual privacy rights. I don't want to delve too far into the CTA itself, but you, I think, in our last podcast, really articulated what the Congress was trying to get at by regulation in this area. So, could you maybe remind us of the issue that Congress saw and was trying to resolve, even if it's balanced against privacy rights?
Absolutely. And in this particular case, the plaintiff had made privacy arguments. This court, however, did not touch on those privacy arguments. It limited its ruling to the Commerce Clause and the Foreign Affairs provisions. But the CTA, of course, requires reporting companies to file these reports with FinCEN that identify the beneficial owners of the company. And for each beneficial owner, provide 5 pieces of information, which are full legal name, date of birth, residential address, and then a unique identifying number, which may be a driver's license number or a passport number, and then provide an image for that driver's license or passport. So every company that is required to file, roughly 32 million we expect of this year, providing those 5 pieces of information for every beneficial owner. The argument from the plaintiff's point of view is that's an intrusion on my privacy. My beneficial owners shouldn't have to disclose that information and just to form a corporation. The contrary argument is that this information is necessary from the government's point of view to prevent money laundering. Money laundering, of course, is a technique in which illicit actors make their revenues appear as if they are legal by disguising them in some way, often by disguising their true relationship to the company. By disclosing the beneficial owners of companies, law enforcement will be able to track the responsible individuals from the formation of the illicit revenue to the disposition of that illicit revenue. And that is the fight behind money laundering. And that's why Congress adopted the CTA.
Michael, I think both of us, if not are troubled by this decision, certainly take some opposite or a different view around U.S. international or U.S. treaty obligations and how they relate to the Corporate Transparency Act. Maybe take a little bit of a deep dive into that, and we can both say why we think the court got this part wrong.
Yeah. So the United States is a party to a number of treaties and international obligations that obligate the country to take steps to identify beneficial owners of companies. And it's important to realize that from a constitutional point of view, a U.S. treaty obligation is on a par with our constitutional obligations. There are cases that we all learned in the first year of law school about how treaty obligations can override contrary state regulations. For example, there's the case about the migratory birds and the hunting licenses, and the treaty trumps the state hunting licenses, is what you remember from that. One of those treaty obligations is a 1999 treaty called the International Convention for the Suppression of the Financing of Terrorism. And the idea was that the United States, acting as a leader, got together a bunch of other nations to say, hey, let's all make sure that we have the ability to hold responsible individuals within our state territories who are responsible for financing terrorism elsewhere in the world. That obviously this treaty was adopted just before September 11, 2001. It was ratified by the Senate just a few months after September 11, 2001. So that treaty stands on a par with our constitutional obligations. And Article 5, Section 1 of that treaty says that each state, each government that is a party to it, agrees to take the necessary measures to enable a legal entity located in its territory to be held liable when a person responsible for the management or control of that entity has committed an offense, meaning terrorist financing. If the United States is obligated to hold the individuals that control legal entities in its territory liable, how can it do that without the means to identify who those responsible persons are? And that is one of, I think, the legal justifications for, the constitutional justifications for the CTA, that we need to have a law that empowers the federal government to identify the beneficial owners behind legal entities, corporations, and LLCs.
Like, I would just add a couple of points. Number one is if a U.S. treaty has been ratified by the Senate, it has a full force and effect of U.S. law, and we have Senate ratification. There are other types of treaties, bilateral treaties, and others that may be treated differently. But if it's ratified by the Senate, it has the effect of law. And many of the listeners to this podcast come out of the anti corruption world, obviously, with the FCPA. And one of the seminal FCPA cases is US versus K, which cited to the US's treaty obligations from the 1998 OECD and upholding a criminal conviction. I think we're well versed in that law. There's another area that the court named on a heading, but really didn't touch, I thought, in its opinion. And the heading read, get it right, foreign affairs and national security. And I want to focus on the national security because when we visited last time, I really thought you articulated a national security need around the CTA and how the Biden administration certainly has elevated money laundering, anti money laundering, anti terrorist financing to a national security issue. Now, the court did not discuss this, even though it named it in a title or a header, but do you see national security issues under the CTA as well?
Oh, absolutely. Absolutely. If you think about what led up to the September 11 attacks, where you had foreign individuals coming into the United States, they were getting financed by foreign organizations, Al Qaeda. That cash came into those individuals through our banking system and then were spent by those individuals on their upkeep and coordination as they prepared for their attacks, including all the flying lessons that they took. All of that was possible in part because the corporations that acted as intermediaries by holding bank accounts that accepted cash and then distributed it were anonymous. So by eliminating that anonymity, at least on the basis that the CTA contemplates, is directly linked to national security when we're talking about money flowing into and out of the company, into and out of the country being used by foreign actors.
And Jonathan, you've also articulated a couple of other reasons that have really come to the fore since 9/11. That's human trafficking and drug trafficking as well.
Absolutely. September 11 is an easy one when you're talking about national security, but human trafficking, clearly something that affects everyone. It's a horrific crime. It is a huge crime. It affects millions of people every year. The United States is a focus in human trafficking, both on the trafficking side as well as on the financing side, primarily because we have so much money and our banking system is relatively porous, precisely because of the anonymity of corporations. With respect to drug trafficking, one of the key issues at the moment is fentanyl coming into the United States, almost all of which comes in through our southern border. And you can talk about border security all day long, but if you don't have financial security, the border security doesn't matter as much. The organizations that make money selling fentanyl into the United States that results in deaths of, I think the number is around 100,000 people, 100,000 Americans every year. It's a big problem. That money has to flow across borders through organizations, through corporations that have bank accounts. If you eliminate the anonymity of those bank accounts and those corporations, you make it much, much harder for those organizations to traffic in illegal drugs.
Jonathan, there were several reactions to the opinion, some very vociferous, some from FinCEN or the Department of Treasury, which rightly said we will comply with the court's order as it's articulated. But one really struck me, which came from the Main Street Alliance. And they really looked at this ruling, I thought, from the business perspective and talked about the difficulty legitimate businesses had who are complying with the law, competing with those who are not complying. And I was wondering if you might be able to give a few words on that statement.
Yeah, I also saw that quote. I thought that was interesting. I don't know that the purpose of Congress, though, was so much to create a level playing field for legally compliant businesses and not legally compliant businesses. So I don't know that I would put my focus there so much. I don't know that complying with the CTA needs to be so difficult. My company, for one, FinCENreport.com, makes it easy for people to file their reports. It's the government actually has a site on FinCEN.gov that allows you to file for free if you have all the information in front of you. It took me 5 minutes to file for one of my companies. So it's not really that difficult. It's a relatively low bar. I appreciate the focus on compliance being difficult and making it harder to compete with non-compliant businesses, but I just don't see that being an area of focus.
Jonathan, I wonder if you might be able to tell our audience about what you see the next steps from the legal perspective, and then also what are you advising your clients on around compliance with the CTA at this point?
Yes. The court's order only involves the people who were parties to that suit, which is Isaac Winkles and companies that he's a beneficial owner of, and then the members of the NS that were in effect when the court's order was issued. FinCEN's statement, as you noted, said that they would comply with the order. So those are the only individuals who have been relieved of any duty. Every other company in the United States still needs to file as and when originally required. Now, this particular lawsuit was in the Northern District of Alabama. The appeal will go to the 11th Circuit Court of Appeals. Given the usual timing of those cases, it is extremely unlikely that we get a ruling from the 11th Circuit before the end of 2024. What that means is that every company that is going to have to file, that was required to file by the end of 2024, is still going to have to complete that process. And we are extremely unlikely to hear from the 11th Circuit before then. I've seen a few law firms suggest that we should sit back and wait and see what happens and perhaps delay our reports. I don't really see any value in delay. There are no facts that are going to change between now and December 31, 2024 that are going to make a difference. So companies that are formed in January have their first filing deadlines coming up at the end of March, beginning of April. And any company that existed before 2024 needs to get its report done before the end of this calendar year.
Jonathan, you mentioned your company, fincen.com. I would ask you to end by telling us about your organization, what it does, and how a lawyer or other might be able to interact with you and perhaps contact you for some counseling or guidance.
Thank you, Tom. I appreciate that. To be careful, though, it is fincenreport.com. The government is fincen.gov. We are fincenreport.com, but that's okay. We are easy to find. You can click on a button on the upper right-hand corner of our webpage and create a personal account for free and check out the software and see if you can find it helpful. If you have a law firm or accounting firm that would like to work with us, you can reach us at info@fincenreport.com, and someone from our group will reach out to you and let you know how you can work with us. We have a product that allows law firms, for example, to organize hundreds and even thousands of client companies inside of the software, allowing you to guide those client companies towards compliance in a way that allows you as a legal professional to add value to the process.
Jonathan, I wanted to thank you again for taking the time to visit with me. This is
Sure.
obviously a very significant decision. A lot of us are going to be following it. And I wanted to tell you, I hope we can continue this conversation.
Sounds great, Tom. I appreciate it. Look forward to talking to you soon.